Hello friends, this is Sanjay. This is part 6 of the series in which we are covering Constitutional Law 1 and 2 as per the standard LLB syllabus. You will find the complete playlist for this series on the Lawment YouTube channel. Download a PDF copy of the Constitution from this URL and read through the articles, explanations and the footnotes after every video. If you have any questions or if you feel I have missed covering anything important, then post a comment and I will try to address your feedback in one of the next videos. In this video, we will be covering the right to constitutional remedies guaranteed under Article 32 of the Constitution. We will be discussing about the various types of writs that can be issued by the Supreme Court, which are Habeas Corpus, Mandamus, Prohibition, Certiorari and Quo Warranto. Since Article 226 talks about the powers of the High Courts to issue writs within their jurisdiction, and they are the same 5 writs as the Supreme Court, it makes sense to discuss Article 226 along with Article 32. Articles 33, 34 and 35 are more procedural in nature and not so important from your examinations point of view, so I will cover them very briefly. Next, we will cover another interesting aspect of our Constitution, that is fundamental duties, which are covered under Article 51A. In your syllabus, you might see that Articles 36 to 51 are included, and they cover the directive principles of state policy. Don't worry, I'm not skipping them. I will cover them in one of the next videos. Since we are talking about constitutional remedies, we should first know what this term actually means. In the legal sense, a remedy means a solution, a way of solving a problem, or a restitution for a harm or damage caused. If this solution or restitution is achieved through a court decision or a court order, it can be called a legal remedy. Part 3 of the Constitution guarantees several fundamental rights. These fundamental rights are primarily enforceable against the state, mainly against the legislative and the executive. Now, what happens if these fundamental rights are violated? For example, if a person is facing discrimination due to religion, caste or sex, that would be against the person's fundamental rights as guaranteed under Article 15. The person would normally approach the state, that is, the government or the authorities, to help enforce his or her fundamental rights. But what if the government is not helping in enforcing the fundamental rights? Or the government itself is violating those fundamental rights? This is where the Constitution not only guarantees the fundamental rights in Part 3, it also provides a mechanism for approaching the courts for enforcing those rights. Since these remedies are provided in the Constitution itself, they are called constitutional remedies. The existence of these constitutional remedies also supports a very important legal maxim, ubi jus ibi remedium, which means if there is a right, there is a remedy. A right is a right only if it can be enforced. So the Constitution gives the right, and the Constitution also gives the remedies. Dr. B.R.Ambedkar considered Article 32 to be the heart and soul of the Indian Constitution. We will also be talking about writs, petitions and writ petitions. So you should understand what these terms actually mean. A writ just means something that is written. In the legal context, a writ is a written and formal legal order. It can be an order to do something or not to do something or to stop doing something. A petition is a formal written request appealing to an authority like the government or the courts to do or not to do or stop doing something. For example, you can submit a petition to the municipal authorities to provide a bus stop near your area. Or you can submit a petition to stop the cutting down of trees near your office. A writ petition is just a combination of these two terms, wherein you are submitting a petition, that is, a formal written request to a court, requesting it to issue a writ, that is, a formal legal order. Now, the courts that can issue such writs or formal legal orders are the Supreme Court under Article 32 and the High Courts under Article 226. The high-level process is something like this. A person's fundamental rights are violated. A petition is filed before the court, either by the person whose rights are violated, or in a situation where the person himself or herself cannot do so, then the petition can be filed by a friend or a relative of the person. Or if the petition is in the interest of the general public, then any public-spirited person can file the petition. Because the petition is asking the court to issue a writ, it is called a writ petition. The court will review the petition, and if it has merit, then the court will issue a written order, that is a writ. The writ that is issued can be of any of the 5 types mentioned in Articles 32 and 226. Later in this video, we will take a look at each of these 5 different types of writs in detail. The other important point to note here is that most fundamental rights are available against the state, which means that the remedies or the writs are also available against the state. But there are some exceptions. As held by the Supreme Court in the People's Union for Democratic Rights versus Union of India case, if a fundamental right is also available against private persons, such as the rights under Articles 17, 23 or 24, then the Supreme Court can be approached for an appropriate remedy against the violation of such rights by the private individuals or the private legal persons. Article 32 covers the remedies for enforcement of the rights conferred by this part. The part here is Part 3 of the Constitution, which contains the fundamental rights. Clause 1 says that it is the fundamental right of every person to move the court, that is, to approach the court and file a petition for the enforcement of fundamental rights. Clause 2 lists down the 5 different types of writs that can be issued by the court if it finds merit in the petition filed before itself. Clause 3 says that the Parliament has the power to make and to implement laws which can give any other courts the power to issue writs within their jurisdiction. And such an action will not prejudice or affect the powers of the Supreme Court. As I have already mentioned, through Article 226, the Constitution itself already gives the High Courts the power to issue writs within their jurisdiction. So Clause 3 authorizes the government to essentially empower any other courts to issue writs within their respective jurisdiction. Clause 4 says that this fundamental right to approach the court for a writ will not be suspended except as allowed by the Constitution. The reference here will be to Article 359, which allows for all fundamental rights, including the rights under Article 32, to be suspended during an emergency, except of course the rights under Articles 20 and 21, which can never be suspended. While we will discuss all the clauses of Article 226 in detail in a different video, when we discuss about the powers of the courts, in the context of writs, we just need to understand the first clause of Article 226. This first clause of Article 226 essentially gives the High Courts the power to issue 5 types of writs within their jurisdiction. So, the Supreme Court can issue writs under Article 32 across India, and the High Courts can issue the same writs under Article 226 within their specific jurisdiction. The term habeas corpus is a Latin term that literally means that you have the body. But it doesn't make much sense, does it? That you have the body. What does it even mean in normal English? Well, it doesn't make sense because habeas corpus has been abbreviated or shortened from a much longer sentence in Latin. That means that you have the body before us for the purpose of subjecting the case to examination. Of course, we are talking about the body of a living person here and not a dead body. And by have the body, it means bring the body or bring the person. In other words, a writ of habeas corpus is an order to the detainer that the detained person must be brought to the court in body, that is in person, so that the court can consider the case and decide whether the detention is legal or not. A simple example of how a habeas corpus writ is used in real life is something like this. If a person is detained by the police without any warrant or without a charge, then the person's family or friends can file a habeas corpus petition. They can challenge the legality of the detention. The court will then issue a writ order to the police to produce the person before itself. After examining the details and the evidence available, if the court finds that the detention is unlawful, then it will order for the person to be released. On the other hand, if the court finds that the detention is proper, then it will allow such a detention to continue. While the typical assumption is that habeas corpus writs are filed against the police or other authorities, the courts have actually expanded the scope of this writ, and it is applicable against private persons also in some situations. For example, in a child custody situation, if the parent who does not have custodial rights has detained the minor child, then the other parent can approach the court. and the court can issue a habeas corpus writ ordering for the child to be produced before itself or before the authorities. Like most other fundamental rights, this right also is not absolute. The Parliament can pass suitable laws to place restrictions on this right. But the law should be just, fair and reasonable. And finally, remember what I mentioned earlier, that in an emergency, this right to approach the court for a writ will be suspended. The term mandamus literally means we command. A writ of mandamus is an order issued by the Supreme Court or the High Court to a lower court, a government official or a public authority to perform a legal duty that they have otherwise failed to perform. For example, if a citizen has followed the proper process and met all the legal requirements, then he or she should be issued with a passport. But if the passport officer refuses to issue a passport without any valid reason, then the aggrieved person can approach the court for a mandamus writ. This mandamus writ will order the passport officer to do his duty and issue the passport. If a public authority, like a municipal corporation, is legally mandated to provide a service to which the citizens have a right to, like maintaining the roads in an area, but the roads in that area are not being maintained without any valid reason, then the court can issue a writ of mandamus that orders the authority to do their job. A writ of mandamus can also be issued by a superior court to a lower court if there is an unreasonable delay in deciding a case. The process of a writ of mandamus can be described like this. First, the petitioner should have some legal right. For example, the right to receive a passport on fulfilling all the requirements is a legal right. And the petitioner should have been deprived of that right without any valid reason. And the official or the authority against whom the writ is to be issued should have the legal duty to do or not do something that is causing the petitioner's right to be affected. For example, the writ of mandamus to issue a passport can be issued against the concerned passport officer and not a municipal commissioner. That legal duty to do or not do something should be a mandatory duty and not discretionary. If the court finds that there is no valid reason for the delay or the non-performance, then a writ of mandamus can be issued. In various landmark cases, the courts have upheld the steps and principles in this process. The courts have also held that if a corporation is performing a public duty, then a writ of mandamus can be passed against such a corporation. Prohibition is quite easy to understand. It means forbidding something. A writ of prohibition is issued by a higher court to a lower court or a tribunal to prevent it from exceeding its jurisdiction or acting without jurisdiction, or if the law is not being followed properly. For example, a writ of prohibition can be issued if a magistrate's court is trying a case that should be tried in a sessions court, or a civil court is trying a criminal case, or a tribunal is trying a case without giving the parties a fair hearing, or a lower court is acting under a law that has been declared unconstitutional, or a court's actions are in violation of the principles of natural justice, or a court's actions are in contravention of fundamental rights. These examples are based on several landmark cases where the courts have clarified on the scope of writ of prohibition and its applicability in various situations. For example, the writ of prohibition can be issued against any judicial or quasi-judicial authority. The writ can be issued even if the proceedings before the lower authority are still in progress. The writ can not only be issued when fundamental rights are actually violated, but also when there is a threat of violation. Now, remember these two statements. Prohibition is preventive. Certiorari is corrective. Easy to remember because P, C, C. Now, prohibition is preventive because it is issued before the order is passed by the lower court to prevent the decision or the order from being passed. What happens if the order is already passed? That is where the writ of certiorari will come in, which is used to correct a decision or an order that has already been passed. Certiorari means to be certified or to be made certain. The writ of certiorari is used by the Supreme Court or the High Court to review and correct the decisions of the lower courts or tribunals when they have made a legal error or acted outside their jurisdiction or they have violated any of the principles of natural justice. Now remember, I mentioned that prohibition is preventive and certiorari is corrective. Now certiorari is corrective because it is issued when the lower court or the tribunal, that is the judicial or the quasi-judicial authority, has acted without jurisdiction, has exceeded its jurisdiction, has erred in its decision or made an error, or has violated the principles of natural justice. Now, there are plenty of landmark cases pertaining to the writ of certiorari, supporting these statements. To quickly summarize the differences between a writ of certiorari and a writ of prohibition. Certiorari is corrective in nature. Prohibition is preventive in nature. This is used to quash an order or a decision that has already been made. This is used to prevent an order or a decision. So logically, this can be issued after the order or the decision is made, and this has to be issued before the order or the decision is made. After the writ of certiorari is issued, the order or the decision is quashed and the matter is sent back to the lower court or the tribunal for rehearing. After the writ of prohibition is issued, the lower court or the tribunal is prohibited from proceeding with the issue before it, and the matter itself is stayed. The term quo warranto literally means by what warrant. This writ can be used to challenge the right of a person to hold a public office. For example, when a person who is not qualified to hold a public office is appointed to that office, or if a person has been appointed to a public office through fraud, or if a person's term in the public office has expired, but the person is still holding on to that role. Now, quo warranto can be understood better by looking at some of the landmark cases where this writ has been discussed or issued. In the University of Mysore versus C.D. Govindarao case, the validity of the appointment of an assistant professor was questioned. The Supreme Court held that when the appointment is made by taking into consideration irrelevant materials, then a person who is affected by such an appointment can challenge the validity of the appointment by a writ of quo warranto. The decision was that the appointment was held to be invalid. In the Jagannath Prasad Sharma versus State of Uttar Pradesh case, the appointment of a Chief Justice of a High Court was challenged on the grounds that he did not have the requisite qualifications. Here, the court held that the President's decision to appoint a Chief Justice cannot be questioned using a writ of quo warranto. In the Jamalpur Arya Samaj versus Dr. D. Ram case, the appointment of Dr. Ram as the principal of a certain college was questioned. The court held that if the appointment is made by a competent authority and in accordance with a statute, then the writ of quo warranto cannot be issued. Articles 33, 34 and 35 are supplementary articles, and even though they have a lot of text, they are quite simple. So I will briefly mention what they actually say. Article 33 says that the Parliament can restrict or abrogate the application of fundamental rights in relation to members of the forces. The term forces includes the military, that is the army, the navy or the air force, paramilitary forces such as the CRPF, the BSF or the Coast Guard, or the police forces, or any other analogous forces such as the CISF, that is the Central Industrial Security Force. And many of these analogous forces are again technically paramilitary forces. Article 34 gives the power to the Parliament to indemnify or to protect a person who has contravened or violated the fundamental rights of persons in an area where martial law has been imposed. For example, a police officer prevents people in an area from exercising their freedom of speech in the place and during the time when martial law is imposed. The Parliament can indemnify and protect the police officer against any legal action that may be initiated by the affected persons. The preconditions are that martial law must be in force at the time and in that place. The police officer was in the service of the union or the state, and the police officer's actions were done to maintain or to restore order in the area where the martial law was in force. As we have seen, Part 3 of the Constitution covers the fundamental rights, their applicability, the restrictions and their enforcement. Article 35 says that with regards to the provisions given in Part 3 of the Constitution, including some specific clauses under specific articles, only the Parliament shall have the power to make or amend any laws that will affect the rights and restrictions under Part 3. The state legislatures do not have the power to make or to amend any such laws. While Articles 33, 34 and 35 are not so important from a syllabus or an examination perspective, do read the actual text of these articles so that you are aware of them. Part 4a has one article, that is Article 51a. If you see any parts or articles with such alphabets after the numbers like 4a and 51a, you can assume that they were not part of the original Constitution and these were inserted later on through an amendment. Now, as mentioned in the footnotes, Part 4a was inserted by way of the 42nd Constitutional Amendment in 1976. This amendment was a controversial amendment that was passed during the period of emergency which was declared by Srimati Indira Gandhi. It was so extensive and it changed, added and deleted so many things in the Constitution that this amendment itself was called a mini Constitution. While the rationale or the reasons behind many of the other changes, additions and deletions that were done through the 42nd Amendment were either stated or were apparent, there was not much of a clarity behind why the fundamental duties were introduced. Some of the opponents of the 42nd Amendment even claimed that these fundamental duties were introduced to camouflage or to divert attention from some of the other controversial changes. If you read through the text of these fundamental duties, they are quite simple and easy to understand. They are essentially the ideals that should be followed by all citizens of India, such as respecting the national flag and the national anthem, or to stop and prevent any practices that are derogatory to the dignity of women, in simple words, to respect women, or to protect and improve the natural environment. Originally, there were 10 fundamental duties, and the 11th one was added in 2002 and came into effect from the 1st of April of 2010. This fundamental duty to provide opportunities for education to children was added when the right to education was added as a fundamental right. Fundamental duties are non-justiciable to start with. That is, they cannot be enforced in a court of law unless there is a specific law enacted to do so. For example, even though it is listed as a fundamental duty, a private person cannot be forced to do anything to protect and improve the natural environment. But a person can be prevented from doing any damage or can be punished for causing any damage to the natural environment through various environmental laws. In some situations, the existence of a fundamental duty may create a fundamental right for someone else. For example, the fundamental duty to treat women with respect, if it is not followed, may affect the fundamental right of women to be treated with respect, that is, the right to dignity. There are some interesting landmark judgments pertaining to fundamental duties. In the Suryanarayan versus Union of India case, the court held that fundamental duties cannot be enforced by writs. Where there is no law to give effect to a fundamental duty, then a writ of mandamus cannot be sought against any individual who is not performing that duty. In the Visakha versus State of Rajasthan case, which is the case that led to the Visakha guidelines, the court held that if the non-observance of a duty by one citizen can be established as a violation of the rights of another citizen, then the courts may provide an appropriate remedy. For example, if the duty to renounce practices derogatory to the dignity of women is not followed by any person, and such a derogatory practice violates the right to dignity of any woman, then the courts can be approached to provide a suitable remedy. In the AIIMS Students Union versus AIIMS case, the court held that even though fundamental duties are not enforceable by the courts, they provide a valuable guide and an aid in the interpretation of constitutional and other legal issues. A similar viewpoint was expressed by the court in the Om Prakash versus State of UP decision. Now, fundamental duties enjoined on citizens under Article 51A should also guide the legislative and executive actions of elected and non-elected institutions and organizations of citizens, including municipal bodies. And with that, we have come to the end of this video. If you have any questions or feedback, post a comment. I will see you again in the next video. Take care and stay safe.